Hi, I'm Tony Munter, a whistleblower reward lawyer with Price Benowitz in Washington, D.C., and I want to talk a little bit about the statute of limitations under the Federal False Claims Act. Now, this is something that gives lawyers a headache and clients a headache too, because there are actually three different statutes of limitations under this one law. The first and simplest is for the anti-retaliation provisions. If you've been wrongfully fired because you blew the whistle, under this law you have 3 years to report it or lose the right to sue under those provisions of the law. This was actually a compromise because the Supreme Court originally determined that the normal statutes of limitations under the law did not apply to this particular provision of the law. So the law itself was amended, and you now have 3 years, which is under employment law circumstances relatively generous, to file under the anti-retaliation provisions of the law. The next two are a little more complicated. The general rule for the underlying fraud is 6 years, except in certain circumstances when it's 10 years. If the government has not heard of or had no reason to hear of the underlying fraud, it's possible that the statute of limitations can be extended to a full 10 years. That's a complicated one, and you should obviously check with your counsel as to whether or not it applies. Now, as a general rule, nobody likes filing old allegations. If you know of fraud, the smartest thing to do is to find out if you have a case as soon as you possibly can. Thank you so much for your time.